because she is the lady who changed the geography of this world. She created a country called Bangladesh, which was not existing before 1971. So Sir started his career, his political career, with Madam Indira Gandhi. Then Sir went on to represent the Farrukhabad Lok Sabha constituency twice. And Sir has held critical portfolios in the central ministry. Sir was the Minister for Law. Sir was the Minister for Corporate Affairs. And then Sir's latest assignment was the Minister of External Affairs. My dear participants, External Affairs is a ministry which is generally perceived to be the #2 ministry in any country. So Sir has held that high a position. The next introduction is Salman Khurshid, the teacher. Sir was teaching at Trinity College, Oxford, which very few people know. Another introduction, well, the introduction may go on, but I have to wind up. So the next introduction is Salman Khurshid, the author. Yes, Sir has been writing plays, Sir has been writing books. Sir's play, Sons of Babur, was very popular. And Sir's book on triple talaq, Examining Faith, is a book which is part of syllabus whenever Muslim law is taught. The last introduction, Sir, is Salman Khurshid, the actor. Well, very few people know that right from his school days, Salman Sir has been very active in participating in plays, and he has played roles in during his school days, during his college days at St. Stephen's, and also at Oxford. Sir, to conclude your introduction, I can only say, I wish you had joined Bollywood as an actor. Thank you and welcome.
Thank you very much. Thank you. Very, very, very kind of you. I think I don't deserve such long introduction, but I'll just comment on the last one. If I joined Bollywood, there would be enormous confusion between Salman Khan and Salman Khurshid, and that would have caused a great deal of confusion. Be that as it may, let's look at what we are doing today. First of all, let me just say that it's a great pleasure indeed, and an honor always to come back to DME. I have very fond memories of relationships that I have developed with series of generations from the DME people, young students who've come as interns to my office, people who have I've had the good fortune to recommend to move on in life, to go to other universities for their postgraduate work, etc. And I must say that it's been wonderful. Whenever I've had a chance and I've come to the university to actually come face to face with your very bright young students, I've thoroughly enjoyed it, and it's always something I look forward to. In these days of confinement and social distancing, it's obviously difficult for us to meet face to face, and I'm so very glad that you have done this webinar. I would have preferred perhaps to speak on a substantive subject, subjects that I may have contributed something concrete in terms of your knowledge of law, your knowledge of the legal system, our idea about freedom, our idea about how judges decide cases on freedom. In fact, of late, just yesterday I did a webinar, and I've got deeply interested of late on how judges of the highest courts in our country decide what rights we have. We know the Constitution. We know the Constitution enumerates rights like freedom of expression, rights like freedom of movement, freedom of association, freedom of work, etc., etc. But there are, as repeatedly we are told, reasonable restrictions that can be made by the state. But how do you arrive at reasonable restrictions? What is the kind of balancing that's done between rights of individuals and rights of communities, of society, is something that is interested me deeply for more than one reason. Because in recent months, we've seen the privacy case, Justice Chandrachud writing a judgment on behalf of the court, overruling ADM Jabalpur, the 45th anniversary of which has just been just been celebrated, of the emergency that ADM Jabalpur had endorsed and accepted. In what circumstances, that's a matter of further research and analysis. But the fact remains that the suspension of habeas corpus, suspension of right to, under the Article 21, to come to a court to seek relief on grounds that liberty was being restricted, was rejected by the court at the time. And this judgment, although the impact of that judgment was quickly after the subsequent elections and in the 44th Amendment of the Constitution, the impact of that judgment was considerably removed and taken away. But the judgment remained as it were on the books, and it was only now that that judgment has finally been overruled. But while we overrule that judgment, and that's been welcomed by everyone, and the overruling is done in that very, very important judgment on privacy. There are a series of important judgments that's come from the courts in recent months that have fortified the right of an individual. But we suddenly find that when we come to cases like Anuradha Bhasin and the follow-up of the 4G judgment, or the order that was passed based on Anuradha Bhasin, we suddenly find the same equation between the rights of society or the rights of groups of people and the right of an individual suddenly need to be balanced again. And I ask myself this question: are we really going back to ADM Jabalpur reasoning? Not the necessarily the effect, but certainly the reasoning. So these are things that have got me interested greatly, and I would imagine there will be another moment, another option to talk to all of you. But today we are looking at what legal professionals, what are the challenges and opportunities for legal professionals post-COVID-19. Now, what is going to happen in post-COVID-19 is multi-dimensional. What we had assumed safely to be systems, to be arrangements, to be platforms, to be our way of life, largely was something we assumed would remain with us for a long time. Unfortunately, what COVID has done is that it has put a question mark on all our assumptions. All our assumptions are now under a question mark. Interestingly, although the Supreme Court now has allowed, with certain very tight restrictions, that the Supreme Court has allowed the yatra to happen in Orissa, but most religious events and most religious functions have been restricted. Namaz cannot be or could not be performed for a long time in a mosque. The temple gatherings were restricted. You could not go to a Gurudwara for Gurbani, for a gathering for Gurbani. All that had to be done online. And in a sense, the most fundamental relationship that we have with God was put under restriction. It was suspended. We couldn't possibly have imagined this. Now, I think philosophically and spiritually, this is a major challenge. It's a major challenge because the last call that we make is to God. When everything fails, we appeal to God to help us. Appeal to God to help us. And here
Hello. Hello? Hello? Sir, sir, just a minute. Sir, you are on mute. We can't hear you. Hello? Sir?
It seems that there is some technical problem.
Yeah, sir. Yeah, hello?
It's fine now. I think you can hear me now.
Yeah, sir. It's fine now.
Yeah, it must be something for your. If you just tell me what point, up to what point that you could hear me, then I will begin there.
So we could listen.
Till what point did you hear me, so that I will
We
begin.
just missed for 2-3 seconds.
All right. Okay.
Last
So
2-3 seconds.
it wasn't that bad. Yeah. All right.
Yeah.
So what I was talking about is what COVID and the necessary restrictions imposed because of the pandemic has caused some implications for our relationship with God. I mean, God's house, the temple, the mosque, the gurudwara, the places of worship that we are accustomed to, were suddenly put beyond our reach because of the circumstances to protect us. Now, we seek God's indulgence and we seek God's mercy to protect us in the worst of situations. And here we are discovering, suddenly we are discovering that no, we need to be protected even in terms of accessing God. And accessing God, of course, philosophically, you can access God anywhere you are. Kan mein Bhagwan, we believe in our Hindu religion. In Islam, we can appeal straight to Allah, we can appeal straight to God, as we can in Christianity and as we can in the Sikh religion. There are no intermediaries required, generally speaking, in any religion. Yet we have become accustomed to intermediaries. We have become accustomed to places of worship. We have become accustomed to procedures. We've become accustomed to a way of outreach to God, etc., which all has suddenly been put under suspension. And therefore, there is something that has happened, that we have to replace. Now, will that affect professionals? Will that affect lawyers? The way lawyers think about religion is the big question that we can ask. There is, after all, the law of theology, theological law. There is, for instance, the Hindu law, or there is the Sharia law of Islam, or there is the Christian law. Now, we've always been told by the courts that there are elements of law that relate to life in general, the secular dimensions of law, and there are elements of law that are core of religious law, which are core part of religion, in which there can be no interference by secular institutions, including courts. So you remember in Sabrimala case, there was a difference of opinion between judges. The majority judges, the male judges, said that Sabrimala, Lord Ayappa's sanctum sanctorum, could not be accessed by women of a particular age, and that was illegal, and therefore they overruled the restriction of women accessing the sanctum sanctorum of Lord Ayappa. But the lady judge there, Justice Malhotra, said, no, this is part of religion, this is part of how we look at constitutional morality, that includes the idea of religion, and therefore it would be wrong for the Supreme Court to interfere. And this matter is going to be examined again by a larger bench, because the review is going to be heard by a larger bench. 9 judges will decide. That was decided by 5 judges. So how will we rearrange our life in terms of religious practices? How will we rearrange our life in terms of our relationship with the divine, with the ultimate truth, as it were, based on which we decide how to conduct ourselves on the understanding that we follow a particular faith. That will there be fundamentally think about our religions and how that will impact the life that we lead. This is something that professionals will have to work out in future. It's too vast a subject, and it's too complicated a subject at this point of time for me to even suggest what are the possible ways that we look at it. Similarly, as religious institutions will have to be reconsidered, reimagined, and reconstructed, we will have to reimagine and reconstruct other institutions. What we saw with the migrant labor in our country, and that migrant labor crisis seems to have passed finally, and states where the migrant labor return to their homes are addressing their concerns both of food and of financial security. How much that will be effective and how extensive it will be, it's something difficult to say. But when we speak of social justice in general terms and translate that into social justice in terms of political understanding, in terms of legal understanding, and in terms of legal institutions, rights that an individual has, that we see in Article 21, life is not just life in a bland sense, but life with its dimensions that includes liberty, but it also includes facets of living life in a meaningful way. So the right to education, right to food, right to shelter, right to security, right to medicine, right to various forms of social protections, or the social net, as it's called, the social safety net. Now, I imagine much of that will have to be reimagined and refigured. When the migrant labor was moving out in a crisis situation from places like Mumbai, from places like Delhi, we imagined those horrific scenes where hundreds of thousands of people can assemble at bus stops or assemble at places like the borders of states, etc. There were attempts made by people to assist them by giving them food on the road, helping them. Some people gave them lifts, used their own vehicles. Some vehicles had to be provided, but there was difficulty on how many vehicles were required and how those vehicles could be marshaled and how those vehicles could be organized. And the court was repeatedly, again and again, being asked to intervene. Now, all this, we must remember, cannot be done by the court alone. And that's the reason why it seems in the beginning, the court was reluctant to intervene. The court was being completely flooded with public interest litigations that were being filed by young lawyers, that were being filed by activist persons who wanted the court to intervene. And the court kept saying, we cannot take over the administration of this country. We cannot replace the executive and the legislature. All we can do is to fill the gaps when there are gaps. And here the gap is so large and the conditions are so extreme that we are not even sure that we have the capacity and capability and the wherewithal to be able to intervene and give directions and then ensure that those directions are obeyed by the government. And so in the initial stages, there was this reluctance shown by court, which everybody reacting to in disappointment finally ended up with 100 senior lawyers writing to the court, writing to the Chief Justice to say, please do something. This is something terrible that's happening in the streets and people are walking thousands of miles. So many people have died. Please intervene. And the court then finally did intervene. But look at another issue. The court could intervene to say, please get these people back home. Make sure that there are trains running, make sure that there are buses, those people are brought back home. But court then has another problem. What happens when these people get there? What happens to ration cards? Ration cards of one state, would they be effective in the state where the people are now going to? And for that, the government has already said that we will have portability. In other words, you just need one ration card that could apply anywhere and you could get food anywhere. So a temporary arrangement has been made, I understand, at present, which will work for a while. Similar arrangement was made earlier during floods when the Swaraj judgment of the Supreme Court of Justice Madan Lokur had said that the requirement of a local ration card will be suspended. In fact, people who need food will be given food rations without having to prove that they have a ration card. Now, all this relates ultimately to legal structures. How these rights are made enforceable, how these rights make life effective, and how remedies are made effective is the big question. And these are also reconstruction issues that lawyers will be involved in. But most of all, I think the lawyers are going to be involved in a very important segment of our economy. And that's banking and the corporate segment of our economy. Now, we have, over the last 2 years, seen how insolvency code was introduced and how insolvency procedures have worked effectively to make our economy and the economic structures of the corporate world more accountable, more transparent, and more effective. Now, it's only worked for 2 years, so 2 or 3 years to be able to tell how effective it is would be a premature statement to be made. But we know that even though this is a relatively young field in our country, in past there was bankruptcy that we used to do through the courts. It's now the special tribunals have been set up for insolvency. The idea of an insolvency procedure is that the business should somehow be allowed to run, should be assisted and facilitated so that it continues to run rather than come to a grinding halt. Whereas bankruptcy in the past was something that just brought the business to a grinding halt. And therefore, to maximize the capacity of a running business and to ensure that a running business doesn't fault or doesn't falter was the paradigm change that was done. Now, all that was working well till COVID stepped in. Now that throws everything out of gear completely. What happens because finances have started to falter, that production lines have started to break down, that corporates are under severe stress, etc. There are countries that have found, and I suppose that they have the capacity to find solutions. In the UK, people tell me what the government has done is tax compliance has been postponed for a whole year, so that what taxes had to be accounted for and paid at this time will now be paid one year from now. So they will all go to June and July next year. So that takes care of companies. They have liquid cash available that they can utilize. People who are working, employees, have been given, whether they're in the private sector or in the public sector, they have been given paycheck protection. So 80% of their wages will be paid by the government. 20% can, on an option, be paid by the employer. They will be on furlough. They were on furlough for these 3 months. when it was not possible to be effectively working and effectively attending office or businesses or manufacturing units, etc. But they would have salary come to them. And therefore, they would not be out of pocket. But just imagine, contrast that with what's happening in our country and what would in effect happen in our country. Now, you're all young lawyers and you're going to become young lawyers in the near future. Now, look at what is happening with people who are in the bar, whose cases have dried up. Courts are functioning only in a relatively limited way through the internet. Online hearings are happening, but those online hearings are not necessarily for final disposals and final cases. Obviously, trials are not happening because we still haven't mastered, we still haven't prepared enough platforms, effective platforms that are exclusive to courts to be able to use to fulfill all requirements of an actual court. So many of the lawyers are, like many other people, would be suffering. So there is a suffering of the working class that I talked about, the migrant labor. There's also the suffering of the middle class. The middle class should not be ignored simply because it is the middle class. People's savings in many cases are not necessarily so extensive that they could continue for months at end without further income coming to them. Now, people who live in rented accommodation find that they cannot pay rent. The person who relies on the rent that he receives, the tenant, who receives rent from the tenant, is again going to be in difficulty because the tenant is not able to pay. And you can't just tell the tenant to leave, because the tenant leaves, where will you find another tenant? So the big problem there, again, for the economy. There are special problems of the urban areas and special problems for the rural areas. We still don't know what is going to happen with medicine, for instance, medical support that people need. So all relationships in the economy, and that's a huge, huge, huge task. All relationships in the economy are to be readjusted, recalibrated, and reimagined, perhaps restructured. It may have to be done for a period of a year, 2 years, 3 years, 4 years. We don't know. We don't know how quickly the economy will revive. We don't know whether there will be, in real terms, opportunities by which we can do things that we might not have otherwise done. And therefore, the economy starts funding our lives again in a manner in which, as yet, nobody is certain and nobody has been able to imagine. All this restructuring will have legal consequences. When does conflict arise? Conflict arises when there is a huge amount of money available to people in order to be able to invest it. So if people are working the engines of the economy, if people are putting money into the engines of the economy, and they are expecting returns, and they have legitimate expectations, as we say in courts, legitimate expectations, their disappointments lead to a conflict. Where there is stress and people are unable to meet the legitimate expectations of their collaborators, of their partners, of their coordinators, etc., then that stress leads to legal conflict as well. If in particular sections or segments, the dearth of opportunity of income and the dearth of social support becomes somewhat extreme, then we will have a problem of crime. And if crime is going to be increasing in leaps and bounds, I think in the earlier parts of the COVID lockdown, there may well be data available that crime had actually gone down. But will crime go down? Will crime actually go down permanently? Is a big question. Crime has a lot to do with deprivation. Where someone is hungry, they can take to crime. Where somebody is under stress, they can take to crime. And therefore, crime not at the lowest level, but even at the highest level might become a huge issue and therefore raise the levels of conflict in society, which will have to be handled. While this is happening, and we have seen before the COVID actually set in, there were issues that were disturbing our democracy. The CAA and the NRC protests that had happened in our city, in Delhi, and in fact in different parts of India, including UP and in Bihar and in Andhra Pradesh and in Bombay, had led to a particular kind of divided opinion in democracy. Now that divided opinion, whenever there is a divided opinion in a democracy, it needs to be handled carefully. You have to find common ground. You have to make adjustments and accommodation so that divided public discourse can be handled. Now, before that could be done, and in some cases, as in Northeast Delhi, it got out of hand. The conflict and the confrontation became somewhat harsh, and riots, it led to riots, etc. Again, greater division of opinion. Who is responsible for riots? Who's accountable for riots? Is something that could not be resolved. And before it could be resolved, COVID pandemic set in, the lockdowns set in, and therefore in the lockdown there was this problem of availability of legal assistance. And people normally, what one would have thought is that the requirements of policing for the COVID period itself would be so predominant that accountability, right or wrong, for the period before that might have been put back a little bit, but that's not happened. And when I say this, let us look at what the courts have done. Even in cases of people who have been convicted, and I do know of cases of people who've been convicted of murder by the High Court, but their appeals are still pending or are to be filed in the Supreme Court, are yet to be filed in the Supreme Court. Even in those cases, the Supreme Court has allowed people out on interim bail or furlough. And these are people already tried and tested who have been allowed, obviously under certain strict conditions. Now, while people already convicted are being shown mercy or are being shown indulgence, what about people who are yet to be tried, who are only have allegations against them, who only have not even charge sheets, but only have people charging them with wrongdoing? Why those people should be proceeded against at a time when we have other priorities, at a time when people convicted are being released? Why should those people be proceeded against is a very big question. But ultimately, all these issues are going to end up in court. All these issues will have to be settled, whether we settle them by way of adjudication and court proceedings, or we settle them by way of with the very important additional element that our adjudicatory system and our legal system has introduced over the years, and which is working very, very effectively, and that is mediation. Mediation, arbitration, adjudication. So there are three levels at which disputes between people can be settled. There would have to be major relook at all the three levels: mediation, arbitration, and adjudication. And there'll have to be a relook at them, because in many cases, there would be only domestic concerns involved, but in many cases, it could cut across the borders. So where trade issues are concerned, where trade disputes are concerned, where travel issues are concerned, where employment issues are concerned, they would be not necessarily all limited to within the country, but would go beyond the country to other countries as well. And therefore, we will have to deal with structures that will resolve problems that exist across the borders. And I haven't yet talked about banking. Banking is going to have its own problems because banking survives on giving money out to people to create out of that wealth, which then returns to a bank for the bank then to give it to someone else. Now, if that cycle is broken, then we have a serious crisis, a serious financial crisis. And if there's a serious financial crisis, it will throw up its own conflict, it will throw up its own confrontation, it will throw up its own problems. Now, the word moratorium is being very commonly used these days across the world. The word moratorium. Do we bring some things to a halt, a temporary halt, till such time as we can revive relationships and we can revive the supply chains, and we can revive the sale and purchase, and we can revive the markets? Do you bring things to a halt? Now, when the lockdown was introduced, of course, that was introduced for a different reason. It was introduced so that we had the time to be able to tackle with COVID. A lot of people have questions on did we do the right things, did we not do the right things? But that was only a temporary pause, as it were, for our being able to handle the challenges that we have to deal with in terms of our health issues, not in terms of economy, not in terms of other things. The reversing of the lockdown or the opening of the lockdown has a dual factor. It has the health factor because beyond the lockdown, we must ensure that we continue to control COVID in the way we hope to control COVID during the lockdown. But it has the second dimension, which is about restarting the economy. Because this economy cannot remain halted indefinitely. Otherwise, of course, you could have had a COVID lockdown for a whole year in order to ensure that COVID comes crashing down as quickly as possible. But we know that that was humanly not possible. We know that that was physically not possible. We also know that that was technically not possible. And in any case, we had to open it because we had to open the economy. So if the economy opens up, where in which sectors will moratoriums apply, and what would be the long-term impact and effect legally in terms of rights of people? What would be the effect as far as long-term impacts of the moratoriums are concerned? And the moratoriums will have to be scientifically structured so that they do not provide a break on the revival of the economy, and yet they will have to be structured in such a way that the economy doesn't crush people. Whether we are talking about the working class or we are talking about the middle class, we have to ensure that there is enough support available. So the middle class is critical for the economy to start its engines again. Of course, people say that if we put money in the hands of the poor, they will start going out and buying things. But that's only a certain level of purchases that will happen, a certain level of purchasing power that we get in the hands of the working class. But the middle class, that has been seen in India as the driving force of the Indian economy, the very economy that the Prime Minister and the government were hoping would go to $5 trillion, etc., in a period of the next 3 to 4 years, 5 years. The driving engine of that has always been the middle class. And what the world looks at is the Indian middle class, which is the most promising market for the world. And that is the case for the United States, is the case for China as well. Now, if that middle class is not supported and the middle class doesn't get back on its feet, then I believe that the economy is going to have a very difficult time getting revived. And then finally, of course, there are certain things and issues that you have to deal about the upper class, which provides the investment, which provides industry. Now, if it's true that in the last few years, much of our finance is escaping to countries abroad, that our industry and business are going away to Dubai, are going away to London, are going away to other places. If that's true, I believe it will be the important role of the government, backed by a legal system, backed by legal professionals, backed by professionals like accountants and professionals like bankers. But structuring of that will have to be done by lawyers. That money should not continue to flow beyond India, the borders of India. But if that's what we want to achieve, it cannot be done by force. It will have to be done by incentive. Lastly, is coming back to what I started with, my interest in rights. Lastly, people say the world over that the easiest thing that administrators, government officials, and executive finds in circumstances such as these present circumstances is to put a restriction on rights. That if you want to let people, thousands of people decide for themselves, there is going to be utter chaos. And therefore you restrict people's rights. You restrict people's choice. You restrict people's right to say freely what they want to say. You put an imposition on dissent, etc., etc. That again, finally, I believe is a great challenge for lawyers, because the lawyers will then have to ensure that we face these times of stress and we face these circumstances which are very trying and which are very testing without giving up on our rights. How will we secure our rights? How will we preserve our rights? How will we possibly consolidate and fortify our rights is a big question, particularly when there will be, understandably, there'll be confusion in all our institutions, including in the institutions, judicial institutions, because they have never come across such a terrifying, such a devastating experience in their lives. And certainly all of us cannot imagine how things that happened in the past, the Great Depression in the US, for instance, or the Great Famine of Bengal in the early 20th century, and such other things that people faced after the First and the Second World Wars, that our generation is unaccustomed to something of that nature. Now, I think there are lessons to be learned in how did we see people in Japan come out of Hiroshima and Nagasaki and the defeat in the Second World War. How did Japan so quickly get back on its feet and become such a powerful economy? I think there are lessons to be learned from experiences of people as in Japan, and see whether we can improve upon those experiences, or we can ensure at least that on the basis of those experiences, we get back on our feet once again. So all this inevitably will have to be done by professionals, and lawyers will have a very major role. The legal system will, as I said, have to be redesigned, will have to be reimagined, will have to be restructured, and the legal profession itself would inevitably be affected. People ask me, is this going to be the new norm? Are we going to indefinitely do legal, do adjudication only by way of the internet, by way of online appearances? Many people believe that this should be supplementing our structures, but should not be replacing our structures. But be that as it may, many parts of the judicial system and the legal system that had to be replaced one day by online structures will perhaps move faster in that direction, as the Supreme Court, for instance, has now online filing. You don't have to carry a paper book to the registry. You can do filing of everything sitting in your own chamber. This was inevitable. This had to come one day. But if the Brazilian Supreme Court would have been a paperless court, not today, but 6 years ago, why we cannot become a paperless court is the question. I think that all of us lawyers and judges of the present generation and the past generation will have to confer on, sit down together and find a solution to. But certainly there are many, many possibilities, many, many challenges, and many, many opportunities ahead. Thank you very much.
Thank you, sir. Thank you for delivering a very productive and knowledgeable address. Now we would like to ask the director, sir, if you want to put some inputs.
Well, after sir, I would not like to speak because sir has covered in a very comprehensive manner.
Okay, so we'll be taking up the questions. We'll be enabling the participants to write down in the chat box. So you can post your queries in the chat box now.
Ji and Navjot,
Yes, sir.
there is one query
Yes,
that
sir.
I would like to know from our eminent speaker, Salman sir. Ji, sir, you have rightly said that the legal system has to be online. But sir, if we see in the district areas, most of the litigants are from the rural backgrounds. So they don't even have the access to the legal systems, the online, the computers, that paraphernalia which is required for this online system. So how that situation is to be cope up?
Well, I see the point. I mean, this I think is a very important factor. See, today we are doing online because we have to prevent coming close to each other for reasons of social distancing. But this will not be the case tomorrow. So it could well be that you would come to a particular place, you would come to a court premises, but that you actually will use machines to reach, to argue and to reach out to the courtroom rather than being necessarily physically present in the courtroom. Now, for that purpose, those people who are on the wrong side of the digital divide, meaning that not everybody has access to digital equipment that the better off people have, would obviously have to be provided a kiosk or a control room from where they could appear in court. Filing certainly is something that should not be a problem, but we still, I think the courts need, the Delhi High Court has produced some software. The courts need better software rather than use the software that's available to corporates like we are doing on the Zoom. This is not specifically to cater to court proceedings. So I think that if we produced better software, that could be utilized. We also have to think of ways and means by which we have to subsidize perhaps equipment, at least for collective purposes. We have to subsidize equipment. We did it after all once upon a time, and we continue to do it for farmers. We make farmers cooperative, we subsidize the equipment that farmers need. We well may need to put together lawyers cooperatives in which subsidized equipment would be given. Now, one thing is, of course, where the court is physically available and somebody does not have equipment or prefers not to use equipment, but actually comes and appears physically. That's one thing. But the other thing is, look at Uttar Pradesh. Now, you have to travel thousands of kilometers to go to a court where you can you can get a lawyer who can appear for you. So at least in such cases, from the districts, you might be able to appear in the high courts, and the high courts could have specially, technically upgraded courtrooms where you could at least do the preliminary hearings from the districts themselves, but for final hearings, travel to the court, and the date of the final hearing should be fixed so that you don't have to keep going again and again. So I think there are many, many possibilities, but somebody will have to sit down and think about what does this do? Who is disadvantaged and who is advantaged by our switch over to the digital system?
So we
Right,
have
sir.
a
Right. Thank you.
So we have a query from one of the participant that whether the IPR law needs to be changed, especially in medical industry post COVID-19.
You're saying that what should be changed? The idea of law.
Yeah. Yeah. In
Well,
IPR law, should there be any
IPR,
change?
in IPR, see it when I talked about the corporate sector, inevitably something in the IPR area will also have to be readjusted and reworked. But it's too vast. It's too vast a territory for me to say here what should be done. I think we need to look at, as I said about the digital divide. I think similarly on the IPR issue as well, we need to look at what are the the consequences of what has happened with COVID and how we can change. I ask myself one question. Somebody is developing a vaccine. Somebody is developing a cure for COVID. Now, if the vaccine comes in December or the vaccine comes in January or February, and we need to vaccinate the entire country, India has to be vaccinated. It can't be that you and I get ourselves vaccinated, but the poor people who today have to get food on a ration card are not vaccinated. So we must start thinking about how vaccinations will happen. There is Ayushman Bharat, etc. But what is the coverage of Ayushman Bharat for an average citizen? We don't know. That data is not available. But if you have an Ayushman Bharat card, you should be able to go to any of those nominated hospitals and get the vaccine against COVID. Then this would be effective. But those who don't have the cards, what happens to them? It's like those who don't have the ration card today, and are they going to go hungry? And the answer is no. We have to find some solution for those who don't have a ration card. Similarly, we have to prepare ourselves for the enormous cost of vaccinating this entire country, because you can't then be mean and say, I'll protect myself, but let the others die. You can't possibly be permitted to do that. Right? And we must start thinking about this. So similarly for IPR, also we'll have to start thinking, look at what the issues are, and then see what solutions we can find.
Thank you, sir. Thank you for an amazing answer. There is a query from one of the participant. She says that will we will be able to establish the uniform civil code, or it will remain a dream?
No. I think that uniform civil code has to be understood. If it's a dream, it must be a dream that wants to achieve something, not just a dream that there should be a uniform civil code. Now we have a dream today that there will be, as soon as possible, a vaccine against COVID, right? Now that's not a dream simply out in the open. It's a dream because we want to protect our citizens. We want to protect ourselves and everybody else around us. That's why there is a dream. Now, when there's a dream of a uniform civil code, the question we need to ask ourselves is, for what purpose? If we get a uniform civil code, what is it that we'll achieve? Now, whatever we want to achieve, if that can be achieved with or without the civil code, we should say the dream is that everyone will have this. Now, if there is a uniform civil code, every marriage, every woman, every child will have the following things. Then I believe that the uniform civil code is certainly is certainly a dream to be cherished. If that is not what it achieves, but just achieves a uniform civil code, then I believe it is more to do with daydreaming than to actually dreaming.
Thank you so much, sir. Now, I would like to ask, we have with us the kind presence of Honorable Director General, sir. Sir, can you hear me? Justice Bhavat
Yes,
Singh, sir.
yes, I can
Yes,
hear.
sir. Yes, sir. So I would like to, ask you to also kindly put some light on the topic which we have discussed today.
Yes, Mr. Salman Khurshid has already observed so many suggestions, so many difficulties coming across post COVID-19 in the legal profession. But certainly it would be a challenge and a difficult time. And I recall at this time what Sir Winston Churchill said. He said, an optimist sees a difficulty in the opportunity, but a pessimist always sees an opportunity in the difficult times. So, following that, uh, Mr. Salman Khurshid has already been a very an optimistic person, and he has made so good a suggestions that if we follow them, then certainly the legal profession will have no challenges. But at this moment, uh, when courts are not fully functional, and as Mr. Salman Khurshid has raised the point of the 100 trials, in fact, they would be the sufferers because neither the hearing in their cases would be conducted, nor courts are fully functional. Today, they are working with skeleton staff and by way of video conferencing. But I believe that rather I would like to put a question to Mr. Salman Khurshid, whether the arguments by a lawyer by way of video conference will have the same impact as as an advocate by appearing in the court argues and addresses the judges. May I have your views, sir, on this?
You're asking the wrong person to answer this question. This question should be directed towards you. So that,
Sir,
you would be able to say from the position of a judge how effective arguments on the net are and what the problems may be. I think that I think face-to-face arguments have something special that is lacking when you have arguments on the net. But I found an interesting issue that if a lawyer is making a mistake, then seeing a lawyer make a mistake on the screen is a little more glaring than when you're in a crowded courtroom where a lot of noise and sound gets lost, and therefore the mistake may not be as visible and as specific as it seems when you make that mistake on the screen and where everyone is just concentrating on the screen. So I think it'll be interesting to know from, there were one or two webinars held by sitting judges, including Justice Muralidhar and so on, whether their experience is that there is something lacking in these appearances, or that there is something additional that they are able to get. But I feel that there's a human element in interface and interaction between a judge and the bar, and that is sadly missing at present as far as the digital presentations are concerned. But we may gradually start learning. You may do a course in DME in how online presentations should be improved, how your own presentation and your personal manners should improve in online presentations, and maybe we will learn to do them more effectively in future.
Thank you, sir. I do agree with you. And I remember once I was sitting in a bench with the Chief Justice, And we made it clear at the very inception that Mr. Consul, there is no merit in your arguments and in your petition. So we are going to dismiss it. But the way he went on insisting that we had to grant some relief to him. So that is the difference between the arguments online and arguments physically appearing before a court.
Quite so.
So thank you, sir, for sharing your views.
Thank you very much. Very good to connect. Very good to connect with you again. Thank you.
Thank you. God bless you, sir.
Thank you so much, sir. Now, I would like to propose a hearty vote of thanks to the distinguished speaker, Shri Salman Khurshid, sir, Advocate Supreme Court. Thank you so much, sir, for sparing time out of your busy schedule and delivering a very productive and knowledgeable address. I would like to express my profound gratitude to our Director General, sir, Director, sir, HOA, sir, and Dean, sir, for their moral support and constant guidance. I'm happy to express my vote of thanks to my right hand, Betria Lahiri, for the smooth conduct of the webinar, and also a special thanks to Mr. Kush Kalra for organizing this webinar. And finally, most important, I would like to thank the wonderful audience who have actively participated in the webinar and made it a grand success. Thank you so much. Thank you so much.
God bless you all.
Thank you and goodbye. Thank you and goodbye. Thank you very much. Thank you.
The participants are requested to stay. We are going to send the attendance form now. So participants can stay, rest of you can leave. Okay, so participants, we will be sharing the attendance form now. Priya ma'am, please share the attendance form.
The attendance form has been shared.